All right, let's get into the show. First email question of the night is from Jeanette. With COVID rates dropping, do you think we'll be able to have a normal summer of concerts and travel? And are there legal risks for venues and businesses that open all the way back up right away? A great question.
Right. That's an interesting question, Jeanette. You know, obviously I can't predict how the commercial vendors are going to move forward. I mean, we are in Florida, a lot of things are open, but with respect to the legal liability issues, Florida has passed a statute that severely limits businesses' exposure for COVID-related lawsuits. It was passed earlier in the year and has already been signed by Governor DeSantis, but there's several hurdles to trying to pursue a case based on an alleged COVID exposure. For example, in order to do it, you will have to get a licensed physician to say within a reasonable degree of medical certainty that your injury was somehow caused by the defendant's conduct. In addition to that, you will have to plead what the defendant did wrong with particularity, similar to how we're required to do that in fraud cases already in Florida. Then, in addition to that, they have put an evidentiary burden on the plaintiff to establish that the defendant did not have or did not substantially comply in good faith with the public health mandates that have been in effect. If the plaintiff cannot carry the burden on that particular showing, then the defendant is immune from liability and will win and the case will be over. If not, the plaintiff can proceed, but will still have to prove by clear and convincing evidence that the defendant was grossly negligent in order to have any recovery. So those are some significant and substantial hurdles to even try to pursue a claim like that. And they've also shortened the statute of limitations down to 1 year. So I feel like it's going to be very difficult to have a case that you can successfully pursue. So that's the wisdom of our legislature and how they've decided to handle those.
I think Larry or Chris talked about it a couple of weeks ago when we had this question actually asked by a viewer on the show. And Larry, I can't remember if it was Larry or Chris, but one of them was saying that it may not be something that we see with businesses, but more on the medical malpractice side. Maybe you're in a healthcare facility, you're in an elderly facility, and you catch COVID that way. Is that kind of where you see lawsuits with COVID kind of maybe more common, because maybe it is easier to prove that you caught COVID if you were in a long-term care facility?
I think the chance of seeing a successful case to be able to tick off those elements and to satisfy it is going to be much more likely if, for example, you were in a recovery facility or some sort of medical facility and they failed to properly quarantine folks. That is one example that I can think of where I would see a much more likelihood of success. But outside of that, I think, and you know, there's going to be a difficult time trying to pinpoint exactly where you got it and what they did or didn't do. So that is one scenario where I think you could potentially see it, where, for example, you know, we've heard all the stories about in New York where they put people directly back into facilities when they knew that they still had exposure, and there could be some issues like that that could potentially lead to a successful outcome that you could trigger and meet all of these elements that are required under that statute.